My name is Dr. Innocent Ekpo. I'm a legal practitioner. I'm from Rivers State, and I practice law in Nigeria. On the 28th of July, 2025, I received a call from a leading radio station in Rivers State, in Port Harcourt, asking for my reaction to the RESEC, Rivers State Independent Electoral Commission, 21 days notice to conduct election. And after consideration and deep thought of the state of affairs in Rivers State and all that has befallen the state, I decided to react as follows. The 21 days notice given by Rivers State Independent Electoral Commission to conduct the Rivers State local government election is illegal. It is unconstitutional. It is an affront to the Constitution of the Federal Republic of Nigeria, and the entire exercise and the outcome will become null and void and a nullity. The 21 days notice issued violates the provisions of the Electoral Act, because the Electoral Act requires that 90 days notice must be given before the conduct of any election in the Federal Republic of Nigeria. And this 21 days notice given by RESEC falls short of that requirement of the law, and therefore renders the proposed election, the entire activity leading to it, and the outcome null and void, illegal, and unconstitutional. The Supreme Court judgment of Rivers State local government election held that that election was illegal for non-compliance with mandatory provisions of the Electoral Act. First, it was the Federal High Court who earlier had and determined the matter, that found that the notice given for that election falls short of the 90 days mandatory requirement, and therefore held that the election was illegal, unconstitutional, null and void, and a nullity. This matter went to the Court of Appeal and proceeded to the Apex Court, the Supreme Court of Nigeria. The Supreme Court of Nigeria affirmed the decision of the lower court and held that non-compliance to the mandatory 90 days requirement for the conduct of election renders the election illegal, null and void, and unconstitutional. A breach of the 90 days requirement of law, 90 days notice of requirement by the law, by the Electoral Act, renders the process and the exercise an illegality, a nullity, and unconstitutional. Now, the Supreme Court declared the last Rivers State local government election invalid, illegal, null and void due to non-compliance with the provisions of the Electoral Act. The Federal High Court that first nullified the Rivers State local government election held that RESEC failed to comply with the mandatory 90 days notice required before the conduct of the election, and order electoral laws. This ruling was upheld by the Supreme Court of the Federal Republic of Nigeria. Now, in the case of NDP and INEC, 2012, 14 NWLR, Part 1319, the Court of Appeal held that the Electoral Act confers power to the electoral bodies to publish the notice on election activities not later than 90 days, and that the electoral body is limited to that number of days. It cannot waive or alter it to less. This is the law. Therefore, RISEC is treading a very illegal and dangerous path. They are setting a precedent of disorder and colossal waste of the resources of the people of Rivers State. Having already known that their 21 days notice is illegal and renders the activities, the election, the proposed election and the outcome illegal, null and void, and a nullity. Now, in the case of Ebobamen and FMBN 2002, 17 NWLR, Part 797, on whether mandatory statutory provision can be waived, the Apex Court, the Supreme Court of Nigeria, held that a mandatory provision directing a procedure to be followed in the performance of any public duty is not a personal right and therefore cannot be waived. It is a public duty. It is mandatory and it cannot be waived nor altered. This position of the law was also highlighted in the Supreme Court decision in the case of Menakaya and Menakaya, 2001, 18 NWLR, Part 738, at page 203, particularly at page 501, paragraphs A to B. Also, in the case of Taps Associates Company Limited and Oyebola, 2001, 3 NWLR, Part 701, at page 428. The Court of Appeal held that once a provision of the law is mandatory, it has to be observed stricto sensu, like a slave obeying the order of a master. You cannot waive, you cannot alter. It cannot be waived. This is the law. Therefore, what RISEC must do is to reconvene and issue a fresh 90 days notice in compliance with the requirement of law. Otherwise, their entire activities and the proposed election and its outcome will be a nullity. I am using this opportunity to draw the attention of the chairman of RISEC and members of the commission to listen to the voice of reason, to respect the provisions of our law, not to act like people who have determined to take the path of tyranny, to know clear provisions of the Constitution, clear provisions of the electoral law, mandatory provisions that have been upheld as mandatory by both the Court of Appeal and the Supreme Court of the Federal Republic of Nigeria, and moving ahead to violate it, damning the consequence, is an affront against the Constitution of the Federal Republic of Nigeria. Therefore, I am calling on RISEC to have a rethink, act like a citizen that respects his constitution, respect the rule of law, respect orderliness, and comply with the 90 days notice. It will be a waste of our resources when another court will again set aside the proposed 30th August 2025 local government election on account of non-compliance if any citizen of Rivers State will feel aggrieved and go to court to ask pertinent questions of law, and the court will answer according to the tried and settled principles of law, and the entire election will be pronounced a nullity. Why go this path? It is a waste of our resources. Those who are in authority should know that they are there to act according to the law, not to act as tyrants who block their ears and block their sense of reason. This is an appeal to RISEC to save Rivers State from another calamity, another doom, another wasteful journey, and waste of our resources. RISEC, listen to voice of reason. Thank you. God bless you, ladies and gentlemen.